second time granted him free bond. So the cash bail of 100,000 was disobeyed yesterday. Today we have an order of free bond, which again was flouted. You know, in both of those two proceedings, and you will look at the orders, both courts are saying, that's order number 4 in the first order, and order number 3, actually number 2, the DCI and the IG of police are being told, allow this person to access his advocates, because that right has been denied since Sunday night. All these lawyers you see here have not had access to the person who is seated there. He has not received any counsel. And the courts are saying, allow him to seek counsel. So charges are being read to someone who has not sought legal advice. Again, contrary to Article 49, so Article 1, paragraph A, Roman 1, no, sorry, paragraph 49(1), paragraph C, where he has a right to communicate with an advocate and other person whose assistance is necessary. That has been denied. That's the person who is denied. And the courts have said he's been denied. So it's not mature for that person to take plea before he gets advice from counsel. You know, I have had a look at the charge sheet, and in the particulars, it says that on the first day of August 2026, at Narumoro Shopping Center within Kieni East Sub-County in Nyeri County. Now, those things were said to have been done. You know, this is Nairobi County. The territorial jurisdiction of these matters that are stated in this charge sheet are in Nyeri. This is the wrong forum that we appear in. So, in terms of territorial jurisdiction, we are in the wrong forum. Offenses should be tried by a court within which the offenses are alleged to have been committed. That point, in a court law such as this one, and the courts have said this over and over again, to show Mr. Gachagua will highlight this, that is not a conveyor belt of processing any charge sheet that is brought before it, even when that charge sheet does not disclose any offense. The offense or the section under which this charge sheet is brought is section 94, subsection 1 of the Penal Code, but I do not wish to read it verbatim. Section 94, subsection 1 of the Penal Code. Kindly allow me to read a part of it. It's very short. It says that any person who in a public place or at a public gathering uses threatening, abusive or insulting words or behavior with intent to provoke a breach of the peace or whereby a breach of peace is likely to be occasioned is guilty of an offense. You're not turning to the charge sheet. It only says that on 1st of August 2026, at Narimoro location, knowingly and intentionally used words in Kikuyu language to it, then the words are written here. There is no allegation that these words were made in a public place or at a public gathering, or that the words were threatening, abusive, or insulting. And it is therefore the location where the words were made to, as it was being made, is a very vital ingredient before such a charge is sustained. So therefore, the court should not entertain a charge that will not take us anywhere. Let us save judicial time. They can amend it if they wish to. The last point that I want to address, and it is tied to where I stand. Your Honor, it is not contested that the accused person has been in custody throughout. He has actually been escorted to where he sits. 2 nights he has spent in the court. And Your Honor, looking at the section under which this charge is brought, the punishment for the offense under this section is a term not exceeding 6 months or a fine of not exceeding 5,000 shillings. There are Section 4 of the Penal Code defines two kinds of offenses. One is called a felony, and another one is called a misdemeanor. You know, a felony is where the punishment is 3 years and above, and whatever else is not a felony is a misdemeanor. Meaning any punishment below 3 years is a misdemeanor. Therefore, the offense under which the accused person is charged falls well within the definition of a misdemeanor. You know, Article 49, so Article 2 of the Constitution states as follows: a person shall not be remanded in custody for an offense if the offense is punishable by a fine only, or by imprisonment for not more than 6 months. If the imprisonment is not more than 6 months. This is not a regulation, it is not a statutory provision, it is not a judicial pronouncement, it is the supreme law of the land, which is the Constitution. Article 49, sub-article 2. Today you have a person who is charged with a misdemeanor and who has been in custody for 2 days. And is now brought before you so that you validate the gross violations of his constitutional rights. By allowing him to take plea in these proceedings, despite all these violations, lack of contact with counsel, having been detained without accessing anybody, it is the wrong court instead of nearly here. Your Honor, this will be the gravest form of violation of the rights of an arrested person. Kindly decline to take further proceedings and let the Honorable Member of Parliament from Ukureni to continue with his legislative duties. As a free man or on free board, as the High Court has found. From me, that's all, Mr. Degonjiru.
And I'll be very brief because we are here to challenge the proprietor of the charge before you. And the question that we are putting is whether or not the charge that is before you is sufficient enough to warrant the accused person to respond to the same. I associate myself with the submissions made there earlier on, but only have this to say, Your Honor, that the premises upon which these proceedings are mounted must be supported by the law. And therefore, at a particular time of commencing the proceedings, this court is not restrained from interrogating the conditions president. It has been highlighted before, Your Honor, the transgressions that befell our client before, during, and at the time of the arrest. The court is invited, Your Honor, to interrogate whether there was a whether there was compliance with the Constitution, not violation with the Constitution, but compliance with the Constitution. I am laying emphasis on compliance and distinguishing it from violation because I know my learned friends will go to the Magistrate Act and pull the magical Section 8. But that's what I'm saying. I am inviting the court to look at the application of the Constitution. And that question, Your Honor, of the application of the Constitution has been dealt with by the Supreme Court in the case of Hussein Khalid versus the ODPP, Supreme Court petition number 21 of 2017 at paragraph 23 and 24. Supreme Court, Hussein Khalid versus the AG, Supreme Court petition number 21 of 2017. At paragraph 23 and 24 of the judgment, the Supreme Court, oh yes, I beg your pardon. May I take it again? Hussein Khalid versus the Attorney General and others of the ODPP, Supreme Court, petition number 21 of 2017. Of our interest is paragraph 23 and 24. In those paragraphs, Your Honor, the Supreme Court distinguished between 23 and 24. The Supreme Court distinguished between the responsibility of a court of law to apply the Constitution and to interpret the Constitution. There was a distinction. And the Supreme Court indicated that the responsibility of the interpretation of the Constitution vests with the High Court, while a magistrate court such as this one can apply the Constitution. And of course, the Supreme Court, Your Honor, was coming from Section 20. Sorry, Article 20, Your Honor, Clause 3, where it provides that in applying the provisions of the Bill of Rights, a court shall. The Constitution does not define the jurisdiction of the court. It merely provides the court shall. And therefore the court for these purposes therefore means even this particular court established under this Constitution. And you are told, Your Honor, when applying the Bill of Rights, and again the law, the article provides the word apply, not interpreting. In applying the Bill of Rights, a court of law shall develop the law to the extent that it does not give effect to the rights or fundamental freedoms. So when you're applying this provision, Your Honor, even upon the basis upon which this prosecution was mounted, you are invited to apply the law and see whether there was compliance. If therefore there was no compliance with the law and it is so dictated that there must be a compliance, the question therefore would be, if the garbage in, or is it garbage out? If we have put in garbage, can we get any good end results at the fullness of time? Your Honor, you might want to look at that charge sheet that has been brought before you. You are told that our client ought to take plea for offenses, offensive conduct conducive to the breach of peace. And the conduct is as a consequence of his utterance. And you are told, Your Honor, that there was an interpreter who has interpreted the language from Kikuyu language to English language. Your Honor, we need to look at that propriety of the interpretation itself. And why is it important, Your Honor, before I come to that? Is because Article 50, Clause 2, invites you, Your Honor, Clause 2, Paragraph B, provides that every accused person has the right to a fair trial, which includes
Yeah. My name is Kaguchia, you know, and very briefly. You know, after disobedience of the court order that my learned senior has highlighted, the accused person further went to the High Court in High Court at Milimani, in a different court.
For DPP will say that the Criminal Procedure Code does not allow them or sanction them to accompany a certificate. But again, we are told to develop the law. And the reason why you are told to develop the law, Your Honor, is so that you can implement the strict adherence to the Bill of Rights. Such that, Your Honor, if our client was to respond to the charges, it must not amount to a violation of his rights under Article 50. This is one of the unique cases, Your Honor, where such a certificate is required to make sure that the accused person understands the charges facing him. You know, I have the benefit of understanding the language that is deemed to be offensive, the Kikuyu language. I equally have the benefit of understanding the little English from a school. And you can see clearly the difference. For example, the words deemed to be offensive have used the word kasongo twice. If you go to the interpretation, you only see the word kasongo once. Where did the other one go? And was it material? Number two, Your Honor, I refer you to a thesis. I beg your pardon?
When you speak, this is systematic.
Am I too fast? I'll take it again, Your Honor. I beg your pardon. Your Honor, I had indicated that we are looking at the propriety of the charge and the ability of the accused person to understand the charge. I beg your pardon? Oh yes, Your Honor. So I was indicating, Your Honor, that I have the benefit of understanding the Kikuyu language and the translation, and I credited my English teacher for that. But I said, Your Honor, that if you look at the interpretation, the English interpretation, it has applied the word kasongo once, while the Kikuyu version has applied the word kasongo twice. And then we are told that the reference to the word kasongo amounts to an offense, and it is bordering between the breach of peace, when the same is not definitive. Subsequently to that, Your Honor, just to show you how tricky it is and how careful we need to be in this interpretation, I wanted to refer you to a thesis that was done by Dr. Mwaneki Isaiah Ndongo for his PhD. It's titled The Pragmatic Limitation of Translation and Interpretation of First Language Utterances into Second Language. Of the most importance in that particular language, the good professor indicates the risk that you run in the interpretation. I refer you to, and I will offer this book to you even for your library, at page 6, the statement of the problem and significance of the study. He says, and I just quote, and I hand over the book to you, and I'll also have given it to the prosecution. This begs the question whether the translated and interpreted version of the speech in an ethnic language into English is done in a manner that is socially acceptable and legally appropriate to sustain criminal charges against the presumed offender. You know, you'll have this benefit. Why that thesis, Your Honor, is important for you to have a reference to is to guard the chances of abuse. By the prosecution, and most importantly, the intention to gag. Finally, Your Honor, yesterday when we went to the police station with my colleagues, and we had the benefit of looking at the entry in the OB at Kamukunji police station, the accused person had been, it was alleged that he had violated section 10, subsection 3 of the Election Offences Act. That is the first initial entry of the OB. Today, Your Honor, and just to show you the malice behind this process, they have brought you these charges. I know the OB is not before you. This is for your benefit, Your Honor. So that, Your Honor, a court of law, as indicated by my line friend Mr. Kirago, should not be a conveyor belt just to take anything comes. And the ODPP cannot just say that Article 157 allows him to charge any other person and he should not be questioned. The only safeguard we have against the arbitrariness and the mighty ODPP is the court. So that your pen, Your Honor, may gag the mighty ODPP. So so that the mighty ODPP, Your Honor, will not exploit the benefits of Article 157 to bring flimsy and trump-up charges before you. The only person who can control the weight of the mighty ODPP is you. Your Honor, this morning, as I pen off, I have the benefit of mentoring one John Meadow, the senator from Nyandarua County, who is undertaking his law degree at Nairobi University second year, and I have the benefit of having him before me and promising to be his good people master. Thank you, Honor.
Thank you, Honor. Commission. I'd like to request that Lawrence Karanja highlight very, very briefly the time on High Court case number E517-2006, and then I would request that Mans will be given a minute also to recap on it, and then Mr. Guringa to close our submission. Thank you, Honor.
Yeah, I have two just a brief point on the charge sheet. I associate myself with my two colleagues, my three colleagues, but there is an element of the charge sheet under section 94. There are three keywords. Anyone who threatens, there is a keyword, abuse, the pedophiles, section 94, the one he's charged with. The keywords are anyone who uses threatening, abusive, or insulting language. Therefore, in the charge sheet, I'll say three things: threatening, abusing, or insulting. For an accused person to be able to create, the charge sheet must disclose who was threatened. The charge sheet must disclose who was abused. The charge sheet must disclose who was insulted. Otherwise, the accused person, who is not just a member of parliament, but an advocate, cannot plead to such a charge, which doesn't say who he threatened. The only person who has been mentioned in the charge sheet, and it is not said he was threatened, is a Kasongo, whom we don't know who it is. Because they say there is a Kasongo, he mentioned the word Kasongo. Nobody was, he does not say that he incited anyone, he intimidated anyone, or he threatened anyone. Without such particulars, I would be urging Your Honor to find that the charge sheet is disputed. And as what's stated in Article 50, it clearly indicates that the particulars of the charge sheet must be very clear, so that when the accused person is privy, he knows what offense he is facing, or who are the people whom he abused, threatened, or insulted. Again, on the order which was issued, there is one thing by the High Court, the second order, and that is what we've been finding. The accused person before you actually was admitted to his own personal bonds. He's supposed to be out, not in custody. And you will be urging Your Honor that under whatever circumstances, the first thing is that order be complied with. Let him be released.
Thanks, everyone. Okay, click up. What did I just agree to in that meeting? That's better.
Wait, that's done already?
My team works in ClickUp.
He is there on the dock through disobeying court orders by the police officers who have brought him to the dock. That's all.
Your Honor,
So there's something else I was also informed that even as you go, his phone is still in custody. We'll be asking you that you direct that his Samsung A34. It is looking at the offense which is before this court. It has nothing to do with electronic gadgets. So there is no reason why they should continue holding his phone illegally. That's all.
Again, Your Honor, your kind permission, my name is Daniel Manson. Your Honor, because of denying the accused person an advocate since he was arrested, because the details of the phone are not being gotten correctly, I just taking instruction with print. It is A33, Samsung A33, not A34. And Your Honor, this matter from the two court orders you have is already before the High Court. And the dates have been given, Your Honor, as to appearances when this matter, Your Honor, should be appearing before the High Court. Your Honor, the dates are given in the court order. When it will next be at the High Court, Your Honor. Your Honor, the accused person, again, is an officer of this court. He is an advocate of the High Court of Kenya. We were confirming that fact this morning, Your Honor, because we didn't have access to him. Confirm that he has renewed his practices certificate. I'm also a member of Parliament, Your Honor, from Kuruini constituency in Kenya. Your Honor, the OCS Kaguchia police station halfway refused to follow or to obey two High Court orders. Your Honor is already in contempt, and we wanted to urge that matter in the two court cases, Your Honor, which will be combining into one for Justice Mutai, who is in this premises, so that the DPP, the DCI, and the IG, together with that particular officer, can charge that conduct or face the consequences of disobeying the court. Your Honor, the moment the court is disobeyed, the DPP, who has been working in cahoots with the DCI, have no audience of this court. And they have also no audience of the High Court. Up to the moment they will purge this contempt. Your Honor, we cannot take contempt of court rightly. And Article 159 of the Constitution, this court and the High Court draws their power from the people of Kenya. And Your Honor, having that power in the Constitution and the people of Kenya cannot be disobeyed by a police officer, cannot be disobeyed by this court, nor can they be disobeyed by the DPP and the DCI. In fact, Your Honor, I went further to send this court order to the IG on WhatsApp, just to make sure that in case there is no communication between him and the OCS Kaguchia, he has the communication, Your Honor. Your Honor, this is a public interest case. He cannot plead that he is not aware. The DCI cannot plead that they are not aware. The OCS cannot plead that they are not aware of the protocol. But the easiest thing, Your Honor, they would have done was to check at the CT if they doubted us and obey the court order, Your Honor. I want to reiterate that, Your Honor, the accused person, the Honorable Kaguchia, is already out on bond. We are pleading with you to transfer these proceedings to Justice Mutai who is in these premises, we already have a date where the DPP can respond to their content. And Your Honor, this is for a very important reason, that we cannot create this precedent that police officers will be disobeying court orders and have their way in court. Your Honor, they must know when they breach the Constitution, when they refuse to release under the Constitution for a misdemeanor without holding a person, that Your Honor, they have no audience in this court. And therefore, I want to leave it to my other two counsels. There's an authority have been presented here, and I think the counsel who has gone through it will be the right one to do so. I thank you, Your Honor, and plead with you that today we keep to the Constitution and allow this matter to proceed to the High Court. In fact, you have no matter before you, Your Honor.
If I may, Your Honor, just to give up on what my colleague has said, the binding decision of the Supreme Court in the Atosha Distributors Limited and Kenya Breweries Limited and 6 others. My name is Muge. My apologies. Muge, M-U-G. So Your Honor, the binding authority is the Atosha Distributors Limited versus Kenya Breweries Limited and 6 others. That is 2023 KESC. Dear Tosha Distributors Limited versus Kenya Breweries Limited and 6 others. 2023 KESC. Two 023 KESC. Your Honor, on the decision that a party that has disobeyed court orders does not and cannot have audience for a court, any court. The Supreme Court states that the respondents in that matter could only appear at that point before the High Court to purge the content before they could be allowed audience for court. That position is the same as this position, and that decision is binding on this court. The states in these matters, until they purge their disobedience of the orders of the court, of the High Court, on 2 separate occasions, cannot have audience before you. Your Honor, as long as Honorable Kaguchia sits over there, not free, the ODPP and the states cannot address it.
Yes, good afternoon, Your Honor. Good afternoon, Your Honor. I think the tension was too much in the courtroom when you walked in that your assistant inadvertently forgot to introduce the court. So for the benefit of us who are taking records, we will appreciate if we could get the Honorable's kind name. Sorry. My name still remains Ishmael Gorenga. Gorenga, yes. With an apostrophe, honestly. Allowing to mean different things. So, Your Honor, I wish now to proceed.
I've yet not recorded the court's name for the essence of Honorable Nyangena. Pleasure, Your Honor. Your Honor, I wish to start the summing up our submissions by stating that it is an established principle in law that a dishonest party cannot qualify from a favorable legal relief. A dishonest party, as the IO, as the ODPP in this case have been, and by extension, the National Police Service, cannot benefit or qualify from any favorable legal relief. And this is premised on two grounds about a court order. Your Honor, there are two established norms about how a court order is dealt with, and one of them is obey first principle. When you are served with a court order, the first thing you do is obey. The second one, Your Honor, is challenge lawfully through a review or an appeal. Challenge lawfully through a review or an appeal. As we stand before you, Your Honor, the parties who expect to take a swipe at us after we are done with submissions, that's the ODPP, has not complied with those two principles. They have not responded to the petition. Their clients have not complied with the court orders. And I wish to draw this court's attention to an old precedent. It's a High Court of Kenya, Nairobi. High Court of Kenya, Nairobi, miscellaneous civil case number 1445. High Court of Kenya, Nairobi, miscellaneous civil case number 1445 of the year 2003. Miscellaneous civil case number 1445 of the year 2003. And in this case, Your Honor, the circumstances were similar. It involved, yes, Your Honor, it's a miscellaneous civil case number 1445 of 2003. Civil, miscellaneous civil. It involved the OCPD railways. I beg your pardon? The case number is 1445 of 2003. And in this case, the court quoted a Court of Appeal case number 278, Court of Appeal case number 278 of 1998, Civil Appeal number 278 of 1998. Yes. So the miscellaneous case, the court established now these two principles. You must obey first. And the wording of the first order served upon the OCS Kaguchia was to release the accused person forthwith. That was not obeyed. He is before you in cuffs. Your Honor, that now takes us to that established Court of Appeal case. Which established the norm that you must respect the court orders until they are set aside. Now that takes me to the last liam of our submissions. And Your Honor, the question is, and our assertion is, why these charges before you must be impeached, and why they are is a perfect candidate to be quashed. And Your Honor, we are laying 5 grounds besides what my learned colleagues have put before you, and I fully associate myself with, but we are summing them down to 5 grounds why these charges must be quashed. One is that the charges as brought before you have violated mandatory legal procedures. e.g. the reasons for detention and right to counsel. Your Honor, I will not belabor this, but this ground alone makes these charges fatal. The mistake is fatal. Number two, these charges have violated the constitutional rights of the accused person. They have violated the constitutional rights of this person, the accused, and they have proceeded to bear all the hallmarks of a malicious prosecution. Number three, if the court is with me, is that the charges before court are a product of a process which is contemptuous of the court. The charges before you are a product of a process which is contemptuous of the court. Your Honor, my colleagues have already gone into the details. The other one, Your Honor, is that the charges before you, bear what we can call unquantifiable standard of proof. The charges before you bear what you can call an unquantifiable standard of proof. And just maybe to make the court understand what we are trying to say on this, my learned friend, Mr. Gachagua, has led out to court or had directed the court to draw its attention to the particulars of the offense. And what the court will appreciate, Your Honor, is that the language which the accused person yes, standard of proof. They cannot meet the unquantifiable standard of proof. Standard of proof. Standard. They can not meet the threshold of the criminal required standard of proof, which is on a beyond reasonable doubt. That's essentially what we are saying. For instance, your attention has been drawn to the charge sheet, especially the particulars of the offense, which were allegedly stated in Kikuyu language. Your Honor, I also happen to have a benefit of this language. It's predominantly spoken by our brothers and sisters on a light note, currently trading as hyenas. That is not for the record. Your Honor, this language, unlike other languages, has 7 vowels. The normal languages we know of, Kiswahili, English, has 5 vowels. 7 of them. So that's why in Kikuyu language, you at times is given a kofia, a cap on top. It makes it the meaning different. And that's why, Your Honor, I am always emphasizing to my brothers and sisters in the bench, put my name right with an apostrophe. Because my name without an apostrophe means different things. So, Your Honor, you would appreciate that in that language what I'm told, and I'll go to the first paragraph, the last sentence, there is a word, sha. There is a word in Kikuyu language meaning sha, which means no. So, this charge sheet, Your Honor, proper scrutiny is a waste of the judicious time if this matter proceeds. Your Honor, you've also been directed to consider that this matter is not properly before you on matter of jurisdiction. Section 71 of the Criminal Procedure Code talks about the ordinary place of jurisdiction for obvious reasons. This crime is alleged to have been committed in Almoro, which is around 200 kilometers from here. And there will be witnesses expected to participate. Of course, the audience has alleged, which consumed these words. So, Your Honor, the logistics of even proceeding before you are cumbersome. Lastly, but not the least, Your Honor, I want this court to look at this matter with the lenses they ought to be looked at. Political. And Your Honor, we don't want this court to run the risk of being bad-mouthed that it was a forum shortcut. Maybe my friends and my colleagues, learned friends in the ODPP, will confirm to court that we have over 10 court stations in between Arumoro and Milimani. All with jurisdiction. Why Milimani? So, Your Honor, I proceed to sum it up and give the last ground that the charges before you are not criminally trackable. It involves a political speech, if at all it was given, with imaginary characters, and a name has found its way to the courtroom this morning or this afternoon, a character called Kasongo. And Your Honor, the court cannot move into an arena which is not criminally, or which the court cannot consume the contents. And lastly, the date of the arrest as indicated in the charge sheet. Your Honor, the charge sheet before you. I wish to draw the court's attention to the charge sheet. It is the 3rd of August, the year 2025 of our own. And this is in harmony with something we call the Murphy's Law. What is meant to go wrong will go wrong. All those 50 men in 50 Subarus and my good friends the ODPP will not get sight of that. So the church is following you on, even on those grounds alone. Even the last ground alone cannot stand. So, Your Honor, I beg to rest the submission there. Thank you for your patience and time.
Thank you, Your Honor. I pressure to allow other counsels to say something, but I think during session of my here, but I think for the benefit of time, I think you've been very, very generous with the time. Your Honor, in conclusion, the accused is requesting you to dismiss the charge sheet before you because it does not disclose any offense under section 89(4) of CPC. And you have what you have here, Your Honor. You do not have a legitimate charge sheet. What you have here, Your Honor, is just drama, demonstration of abuse of power. Yes, Your Honor, I'm just closing, Your Honor. I'm just concluding. What you have here is not a charge sheet. It's purely an attempt by the state to breach the Bill of Rights, freedom of expression, It is purely meant to manage politics in this country by stifling opposition. And therefore, Your Honor, with your kind permission, I submit and request this Honorable Court to dismiss the charge sheet. And as the High Court pronounced in High Court number E517 of 2026, we request that you're obliged and give the accused a free bond. Thank you, Your Honor. Thank you for your time.
Your Honor, your kind permission, it is clear that the DPP is in contempt of this proceedings. Your Honor, could you give us a ruling whether they will proceed or not?
Yes.
So that on the basis of that, Your Honor, we have a ground to go to the High Court. They have no audience in this court, Your Honor. Could you please rule whether they have or they don't have? So that, Your Honor, in the event they address this court, then, Your Honor, we need to proceed to the High Court.
Yes, I think I do agree with my senior, Mr. Manzo, that that's a fundamental preliminary point. That
yes, we can do that, Your Honor.
Then Mr. Manzo can make that application, then we can be twice. But Mr. Manzo, Your Honor, we are saying they have no audience before you. Yes, Manzo make that application, we shall support you.
Yes, Your Honor, I would like to make an application before this court, or even raise a preliminary objection, Your Honor. Now, the DPP, the DCI, the OCS Central, so the OCS Kaguchia Police Station, and the IO in this matter, having reached the ODPP, the DCI, the OCS, Kaguchia Police Station, the IO in this matter, Your Honor, based on the two court orders we have pressed before you, and especially the court order of Justice Mutai, and bearing in mind that, Your Honor, these proceedings are already before the High Court, there is a petition, Your Honor, which is in the two court orders. Yes, Your Honor, let me sum it this way. That based on that, and based on the conduct of court, which they have not obeyed, and continues to contend to run in this court, Your Honor. Up to now, the Honorable Kaguchia has not been released on free bond. Your Honor, could you know that they have no audience of this court in accordance with the laws already cited to you, and that, Your Honor, will proceed to the High Court to deal with this matter further, because that is the court. On the face of it, they committed the contempt. Your Honor, my colleagues, if they have more points on that, they build on. I thank you, Your Honor.
Yes, Your Honor, we are here, Your Honor, on the basis of Article 159, which provides, Your Honor, I'm quoting the law, which provides that, Your Honor, judicial authority is derived from the people and vested in the people, and shall be exercised by the courts and tribunals established by or under this Constitution. Your Honor, equally well, the office of the ODPP is established under Article 157 of the Constitution. Are you taking it? Yes, I did it. Yes, Your Honor, I indicated at 159. That's correct, Your Honor. That's correct, and I will not repeat myself. Allow me to begin by Article 10 of the Constitution that lays the principles and the values of governance, among them the rule of law and the Bill of Rights, the doctrines of equity and social justice, which are applicable in these circumstances. Equally well, I'll equally read it together with Article 159, which establishes this court and says that the court derives validity from the people of Kenya. And draw your attention to Article 157, which establishes the office of the ODPP. If I were to harmonize those provisions, Your Honor, I would say that there is, again, Your Honor, Article 27, that speaks about the equality before the law and equal benefits of the law. And as such, Your Honor, when the ODPP appears before you in violation of a court order, he must be looked from the lens of equality. That what is good for geese is equally good for gander. If he has no respect for the High Court, how can he purport to have respect for a subordinate court? He has not denied that there was disobedience of the court order. You saw this, the ODPP. You saw this morning, Your Honor, Honorable Kaguchia was escorted by the court orderlies from the court cells. I was present yesterday with my learned friend, Mr. Waduta, when we brought the attention of the OCS Kamukonji police station of the existence of these orders. He arrogantly said, Mr. Lagat, that this is not a hospital where you walk in and walk out. That's what he said. Today, Your Honor, at the police holding cells in the courts precincts, Mr. Waduta brought the attention of the orderlies again of the existence of these orders, and they again violated them. Our position, Your Honor, is that they have no audience before you unless they purge that contempt. And the only place and forum for purging that contempt, Your Honor, is in the High Court, not before you.
Yes, Your Honor, with your kind permission, I wish to seek the court. I'm raising a very valid issue, Your Honor. Kindly, I seek your audience. And Your Honor, kindly, with tremendous respect to you. And you are not really audible, Your Honor?
You see,
yes.
The language you use.
Most obliged. We are guided. We are guided. We appreciate that. We've apologized and withdrawn, Your Honor. There is an issue I want to raise, and that relates to why she wants to be on her feet. And I wish, Your Honor, you can consider me. I want to make a very important contribution as far as law is concerned. Gorenga is my name. Your Honor, the application raised by, actually I'll take two. The application made by my learned friend and my senior, Mr. Manzo, is in its nature an ex parte application. For these obvious reasons, we are saying that the ODPP has no audience before you. If now you grant them audience to respond to his application, in a roundabout manner, the application will be defeated. Because we say they cannot rise on your feet to address you. That's the nature of application. If they address you and with their word go on record, that means you have granted them the audience. You cannot again withdraw that. That's all.
Yeah, Your Honor, just I don't want to repeat anything. I just want to make the court work easier and also the DPP's work easier. Because of that application and where we find ourselves, it will be very easy for the office of DPP and also the investigative agencies and the IG just to confirm at these junctures of these proceedings that they have complied with the release order on free board, so that from now on, we know Honorable Kaguchia is free, so that then we don't need to have a lot of back and forth, so that after the proceedings, just walk out, because he's free on free board. They just confirm compliance, then we go straight to the main point.
I cannot condemn people.
Yeah, very well. I'm just asking if they can just confirm that they have complied, then has it happened?
Good afternoon, Your Honor.
You are paid what all these councils are questioning is the jurisdiction. Can you make a ruling on the jurisdiction?
Yes. May I proceed, Your Honor? My name is Magdalene Kaguchia. Allow me to introduce the team that I'm with. Mr. Boni Okuma. Magdalene Kaguchia. I'm appearing together with Mr. Boni Okuma. And Ms. Rubut. Ms. Oyagi, Mr. Murage, and Mr. Isiahu. I will all make a brief responses to what Mr. said, but just to begin and as an introduction, allow me to start at miscellaneous criminal case number 070 of 2026. Where the DPP is named as one of the respondents. 070 of 2026. I would like to address the court on it.
You're not for your guidance, just to put the house in perspective. Is she responding to the whole submissions or the aspects of the ability to address you?
Counsel.
Because for me, I think we need to first of all jump that bridge of the ability to address you before purging the content, so that then we understand to what limit can they address you in the absence of the compliance.
I am exactly there. It emanates from these orders that we are now addressing.
So am I getting it right?
So, Your Honor.
Yeah, am I getting right that she's responding to her audience before you? Exclusively because that's what we propose.
It's free. It's free.
Oh, that's correct. That's
Thank you, thank you, Your Honor.
Well,
So, Your Honor, E070 of 2026, where the DPP is named as a party. Your Honor, that order was never sat on the DPP. E070 of 2026. We have also had the Honorable Senator Manson on the DPP. We have also had the Honorable Senator Manzo allude to having sent that order to the Inspector General via WhatsApp. We will not be able to respond on our WhatsApp service from the Inspector General. Your Honor, we are saying it was not served on the DPP, but we have had the Honorable Senator talk about having sent it to the other party, who is the Inspector General of Police. Your Honor, the next case is P517 of 2026. Miscellaneous. A petition, actually. In this petition, from what I can see, it is a High Court criminal petition P517 of 2021, from what I'm reading. P517 of 2026. From what I'm seeing, the respondent is the DCI Bondo office. Unfortunately, this time the DPP is not a party. This is the order that is said to have been issued today, 4th August 2026. Nevertheless, nevertheless, Your Honor, and in accordance with that order, the order is 517 of 2026. That order, yes, that order actually further is compelling the respondents to produce and arraign the petitioner before the nearest court of competent jurisdiction. Your Honor, the DPP not having been a party has nevertheless appeared here today in compliance with this order. At number 5, the order says, but pending inter-party hearing of the said motion, an order is hereby issued compelling the respondent to immediately produce and arraign the petitioner before the nearest court of competent jurisdiction within the time prescribed under Article 49(1)(f of the Constitution of Kenya. And the petitioner hearing is Honorable John Kaguchia. The respondent, and again I say in this case, the respondent here is named as the DCI Bondo office. According to what we have been given for this court today. That's it, the ladies. The petitioner has been arraigned before this court today. There is nothing stopping the DPP from this order from presenting a plea before this honorable court. And there is nothing stopping this court from proceeding to take plea. And at this juncture, allow me to call in my colleague, Mr. Okemwa, to further respond to that application.
Good afternoon, Your Honor. My name is Okemwa. There's a Swahili saying that goes, Mgala muwe akimpe. Okemwa. Why am I saying so? Honorable Manso has alluded to the court that the DPP was served with court orders and they did not comply. For one to get such orders, there needs to be filing, issuance of the orders, service and execution of such orders. The key element that I'm trying to address the court on is on service. And it's very key for us to prove service. Was the office of the Director of Public Prosecution served? The court is supposed to be no. I don't want to speak for the DCI. I don't want to speak for the Inspector General. Thank you.
Thank you.
But what I'm trying to say is, by the time that we were sealing the file, for purpose of making a decision as to whether we are charging or not, there were no such orders. And that's why we are before you. But the key question that I'll go back to, maybe Mr. Ndewa can be able to address this. Is there any proof of service so that you can be able to move from there? And again, at times it calls for diligence. We'll request the court to look at the CTS, the exact orders that were issued, because they have alluded that the orders were served on the CTS. We are supposed to go back to the CTS and look at the CTS, but nobody has invited us to go to the CTS. We didn't know that they approached a court in Kiambu or at Milimani. The one of Milimani, actually, my colleague has indicated to the court that they got the orders this morning. All these are my colleagues. They are our colleagues. They could have even called one of us in the office and say, we have this order. Are you intending to charge Honorable Kaguchia? Then we will get to know that there is a court orders for us to make a forum. We respect the law, we respect the courts, we respect each other. Nobody should lie to you, Your Honor, that we don't speak to each other. In as much as as passions are being pointed towards us. Ultimately, I'll indicate to the court that orders are closed. If there was proper service, with proof to the Honorable Court, we could have even gone to the request or the statement that has been made by Mr. Ndewa. Actually, nowadays it's called Honorable Ndewa. If there was proper service, and he confirms that there was proper service, we could have said that since there's an order of the High Court saying that Honorable Kaguchia is supposed to be out on free bond, so be it. We could have annulled that, but there's no service. We could have discussed that by informing the court that we are agreeable to Honorable Kaguchia walking home. Service leads to execution, and that service must be proper. That's all.
Your Honor, a brief response to that?
I'm not done, Your Honor. Your Honor, Rugut is my name. And Your Honor, my submission this afternoon is that the PPP be allowed to be granted audience for the simple reason that the ODPP was not served.
Yeah. My name is Kaguchia, you know, and very briefly. You know, after disobedience,
Your Honor, your kind position, first and foremost, when I came in this morning and approached Madam Kaguchia was holding the two orders with her above those more than 4 hours ago. Yes, she had them, and that's a proof that she had already been served. Your Honor, the reason I'm saying that is this matter has been publicly known, and I'm sure she printed them from the CTS, because they didn't exist, Your Honor. It's been in all the news since yesterday, and she was holding them, so they cannot deny that they did have service.
Honorable Senator, thank you do not mislead the court. The orders were here in court. I found them here, so you can't say I either brought them or something. You're my senator.
Secondly, Your Honor, conduct of court is on the face of the court. It's the face of the court. It doesn't need, proceedings. And that's why I said, Your Honor, we are also before the High Court. Where will properly urge that it has been committed before the High Court, Your Honor, before Justice Butai. And therefore, it is. Your Commission, Your Honor, could you give us a ruling on whether they should appear before you or not? Say that the contempt is before the High Court, Your Honor. We requested you if this proceeding to first go there, we establish this because they represent the OCS and the OCS stamped and received. I think the OCS communicated.
Only in response on a point of law, I want to refer you to the case of Milka Makoha versus Mwananchi Credit, miscellaneous application, civil application number E152 of 2024 at paragraph 31. Speaks about the knowledge of a court order. It says, Your Honor, and it quotes the case of Shimas Plaza Limited versus National Bank of Kenya, 2015 EKLR. It speaks about the knowledge. Would the knowledge of the judgment or order by the advocates of the alleged contemnor be sufficient for contempt of court? The court says we hold the view that it does. The case number, Your Honor, is miscellaneous civil application E152 of 2024. At least there is no denial of service. E152 of 2024. It's from High Court at Kakamega. The most important paragraph is paragraph 31. The principle is that of knowledge of the existence of an order. And most importantly, the fact is that the person who has initiated these proceedings, the IG, who procured the arrest, is aware of the existence of the order and that there is no response on the part of the IG in Maanzo's application, the ODPP having distanced themselves from that. I'm most obliged.
And Your Honor, just to be fair to the IG of police, he is represented by Mr. Kigera. I know he's present before this court, together with other officers who have had interaction with this court order. And if I may also give some benefit to the ODPP, most of the orders that were made by the High Court are directed to the IG and his officers. So perhaps Mr. Kigera or other officers who he is with can tell the court why they have not complied with court orders. Why haven't they not released? It was not the DPP to release, it is them. They are present in court. Let him release it now so that then we can proceed. He can come and explain why the order has not been complied with. See, it's yesterday. Release on 100,000 money. Release cash, release free, they refuse. And then they come and sit here before the court, tell you, charge this person and take him to jail. Let them take the dog, let them explain what difficulties they have experienced to obey the court orders. Thank you.
I think Your Honor, the standards are requesting that we respond to an issue of contempt as to why we have not been able to order the order.
Yes. You know, I say the ODPP, I give them the benefits. Let them do their work of prosecuting, but the people who are arrested and detained are present before the court. Let them explain themselves. He said he's not representing DCI or IG, so let him not change his position. Let us have the people, the continuous who are here. The flagrant continuous.
The statement sounds political, but I say I am not representing. I say I cannot be able to speak on the aspect of service.
Let them come and speak.
Let them skip. They have to prove that they were service, and that is called the confession here.
This is their stamp. They received. They say the police station is not a hospital.
This is now given to the court too late in the day.
They are here, they are present. IG is represented ordinarily by the